Good morning, WTOB listeners. This is Dylan Greenwood along with Harold Eustache of Greenwood Law, and we're here this morning to present to you For the Record with Greenwood Law, our weekly radio show here on WTOB. Thank you for joining us this morning. And today, our topic that we're going to be discussing are roadside checkpoints. It's a contentious aspect of the law and of traffic law. I know, just speaking personally, I've driven in a number of other countries, and it's just an accepted thing that at any point the police can just wave you down, pull you over, ask to see your papers, go through a bunch of stuff, and you don't have a challenge to it or a protection to it. In fact, what comes to mind is actually Jordan. That's a big thing. They warn you ahead of time. You always pull over or else you're going to be fined, or worse. Well, in the United States, we have a lot more protections because of the Bill of Rights, because of our Constitution. And the Fourth Amendment is a big aspect of that, to protect you from unreasonable searches and seizures. It acts as a shield against a lot of those things. I know I may have given you a little moment of shock there back to our days in law school where our law professors would talk about swords and shields and constitutional law, but the Fourth Amendment truly is a shield, and there are cases that bolster that shield, and then there are cases that you sometimes feel like take away some of that shield that we have as individuals. Well, one aspect of the law that has pretty much remained is this issue of checkpoints. A lot of people think of them specifically in the context of DWIs. I would say most people have seen them as it relates to DWIs or with license, checking for license and registration. That's not the only way or the only reasonable manner in which a checkpoint can be produced, but those are a couple of just flat out examples. But checkpoints are pretty unique, aren't they, Harold?
They are, because checkpoints, I know we just mentioned the Fourth Amendment, and folks might think, well, what, we talked about searches and seizures. What does that have to do with a checkpoint? And a checkpoint is, a stop, an investigatory stop, or is a potential violation of the Fourth Amendment or deals with the Fourth Amendment, because when you are stopped, you are potentially seized. And if you're going to be seized, searches or seizures, but the seizure part, it has to be constitutional, and it has to also be reasonable, which is part of the Constitution, that it has to be a reasonable thing. So there's a certain standard in North Carolina with which we look at checkpoints. But to kind of go back on what you said about the types of checkpoints we have, of course you can have one for DWI and license checks, but you can also have a checkpoint to search for illegal aliens, and also for a particular crime that happens in a particular area. So you kind of see this sometimes on TV. A crime happens, something big happens, and officers start setting up checkpoints to corral what maybe happened in that immediate area.
We're talking about all the bolos, be on the lookout.
Right, and that is authorized, but it's not authorized for just general crime. Looking for general crimes.
Right, and the reason why is because it's a suspicionless seizure. Right. More often than not, these checkpoints are stopping completely innocent citizens, having them have an interaction with the police, talking through something potentially that could get them in trouble, where they should have never been expected that their privacy, their right to privacy, would have been encroached upon otherwise. So normally, to be stopped, you have to have reasonable, individualized suspicion. This does not necessarily, it can have a reason, that's part of the analysis, but that individualized aspect that you normally have to have, it's a general thing.
It is a general thing, and that's why the courts have fleshed this out sort of ad nauseum. We actually have a statute in North Carolina that essentially uses the language of the courts that have, in order to codify this in statute and what officers have to do and in order to make a checkpoint lawful in North Carolina. So part of it starts with has to be designated in advance, a pattern for stopping vehicles and requesting drivers that are stopped to produce license, registration, insurance. So the pattern is generally every vehicle. You can't at a checkpoint say, well, I want to stop red cars and don't want to stop blue cars. Officers have to stop every vehicle, because if you're going to have that checkpoint and you're going to be intrusive in that way and seizing folks potentially, it has to have a pattern of every vehicle, and then there has to also be a written policy, and that written policy is what's litigated a lot in courts, isn't it?
Yeah, absolutely, because that written checkpoint policy has to be admitted into evidence in a court of law under that statute, under that North Carolina general statute, or else the checkpoint must be suppressed. So if you can't have an officer that lays a foundation for that, if you don't have the right people there, from a prosecutorial standpoint, then you're in a tough position for whatever crimes or things were discovered based off of that checkpoint.
Right. And for our audience, what suppression means is essentially that. We're saying anything that happens subsequent to a checkpoint, if the checkpoint is unlawful or there isn't a written policy introduced in court, then any evidence found after that has to be suppressed or essentially cannot be used in a court proceeding. So that would basically, end the case for most cases.
Well, I think it's important to note that the statute says that you got to have a written checkpoint policy, but you also have to have authorization for the checkpoint. And those are two separate things. They both have to be there. And just because you have a checkpoint policy, which lays out, the general framework for how and why you have the checkpoint, it doesn't necessarily authorize the checkpoint. That's an entirely separate thing. So, us as an attorney, we're on the lookout for all those different pieces of paper, making sure that they are properly done. And, we hear so often in our jobs, well, when you do stuff like that, well, you're, potentially getting somebody off on a technicality, or,
right.
You're just looking for a really technical thing. Well, no, our job, the way I see our job, Harold, is to be on the front lines for the Constitution.
All right.
And to make sure that, everyone's constitutional rights are protected as much as they can be through our criminal justice system, as much as we can push it. Because at the end of the day, you may not ever think that you're going to need this protection until the day that you do.
Right, and that's why, not to get into a whole history lesson, but that's why the founders found it so important to put these provisions in our Constitution, in the meat of our Bill of Rights, and wouldn't ratify a Constitution without these protections.
But
They're
what is interesting with that, though, Harold, we're having to apply these principles and these laws to stuff like motor vehicles that were never thought of or conceived of at that time. And we're having to, make the best of it. And I do think that I don't agree with every Supreme Court decision that comes out about Fourth Amendment stuff. But I think that a lot of this gets it right, as it relates that if you're going to allow checkpoints from a law perspective, then there are enough provisions to make sure that the public's constitutional rights are protected, that I think it's okay. In theory. And the reason why I say that is because a lot of this stuff that we're talking about, the burden of proof isn't on us as defense attorneys. It's on the state of North Carolina. But that's not necessarily how it plays out in a court of law.
A lot of times in a court of law, it's defense attorneys that are saying, we are challenging these checkpoints and saying, well, was this done right? Was this done right? Because it is complex. And as you said, there's a lot that has to happen. But really, the state has to show that this checkpoint was constitutional, that there was a reason to stop an individual. And so you're right. I mean, a lot of times in court, it just doesn't play out that way, unfortunately. And it becomes this sort of back and forth. But But these challenges to checkpoints are very, very important, and they can be very technical. And a lot of times they come down to, the analysis that the courts do. Was there a primary programmatic purpose? And we'll talk about that for a second. And we look at other factors about whether it was reasonable, whether the actions of the checkpoint were reasonable after having a primary programmatic purpose. But that primary programmatic purpose is detailed in the written policy of a checkpoint. The checkpoint has to generally be in a random place, and that's part of the statute in here in 20-16.3, that the checkpoint has to be in a random place. So, for example, you can't say, I'm going to put a checkpoint, right outside of our workplace here, every day for the next month. That is not a random place. That would not be authorized, because the checkpoint just has to have some randomness into where they're placed all around a jurisdiction.
Yeah, a good way to think about it is that there has to be some thought behind it. Mm-hmm. If you and I were police officers here in Winston, we were just sitting around the station and we were going, tonight feels like a good night for a license checkpoint. I think we should set one up over there off of Silas Creek Parkway, just on a whim.
That's the quickest way for it to be shut down in court.
Exactly,
if that happens,
because there's no primary purpose that's set out, and it may not do that. Because let's say we set out and we said that the primary purpose of this is a license checkpoint. We're going to check everybody's license as they travel on Silas Creek Parkway, and we're doing it in the dead of night. That's an interesting aspect of this, isn't it, Harold? Because how many people travel in the dead of the night?
Not many.
If you want to actually try to find what you're looking for that you've identified as the primary programmatic purpose, then it has to kind of align with what you're doing. So if it is a license issue and you're doing it at 2 a.m. in the morning, well, when do most people actually drive? Most people actually drive during the day. So it's a whole lot. It would be more conforming to the primary purpose of what you're doing if you're setting it up for a time of the day where people actually drive. Now, if your primary programmatic purpose, which is authorized by law, is to try to check for DWIs, and you got to say that, and you got to back it up. There's got to be reasons why you're doing it at this specific place at this specific time, and what kind of outline what you intend to try to look for. But even then, there are a lot of potential issues.
Yeah, I mean, there are a lot of potential issues. One, you've got to identify that you're law enforcement. So these checkpoints have to have blue lights. It's part of the statute. So people have to be able to see that this is law enforcement. You have to be very identifiable as police. And that's for obvious reasons, for safety of the officers and safety of the public. Also, the checkpoints have to be publicized in the sense that it has to say there is a checkpoint coming within a certain radius of this checkpoint, so that the public knows that there's a checkpoint coming. In addition to that, the checkpoint has to be reasonable in the sense that it can't hold and seize a person for an unreasonable amount of time. So there's lots of case law about how long that is. Generally, it's around 15 seconds, which isn't very long for an officer to say, okay, license, registration, everything's okay, make some independent determination about whether there's some other reasonable suspicion for some other crime happening, and let that person go. So it needs to be pretty quick in the seizure. If the seizure becomes very long and drawn out for every single motorist, that could be a constitutional issue about the reasonableness of it.
Now, one thing I'll address about what you just said, where you talked about how it's got to be posted. Hey, there's a checkpoint coming up.
Sure.
Well, I know you and I have both seen cases where people decide to turn around.
I was thinking about that.
right before the checkpoint. Well, if officers get wind of that, they see that can be separate reasonable suspicion.
Absolutely.
Pursuant to the Fourth Amendment in the normal context of the Fourth Amendment to pull you over and inquire, well, sir, ma'am, why did you turn around before this checkpoint?
Right, and we've seen numerous cases where that is the case, where someone sees a checkpoint, and turns around and then is pulled over subsequently, and that is again a reason for the officer to stop you. A lot of times these checkpoints are put in places where they can be seen, but sometimes places where it's hard to turn around for that purpose. But if a person does turn around, and they're put in a place where in the normal course of driving, it wouldn't, it necessarily, you wouldn't just be turning, there. A lot of times, I don't know how to describe it, but they're put in places where they,
you're kind of bottlenecked.
You're bottlenecked in to not be able to, for an officer to say, no, you turned around for the purpose of evading this checkpoint, not because you were going to McDonald's. So that's part of the calculus here in these checkpoints, and part of the reason that when these checkpoints, the places of these checkpoints are picked, it has to be very well thought out. It can't just be on a whim. It can't just be, let's just put it here for general purpose. It's got to be very well thought out and well documented as to why that's happening. Again, and another thing that we touched on earlier was about the checkpoints being for just looking for crime. And I know that may seem like a distinction that doesn't make sense to maybe some of our viewers, but because we were talking about license checkpoints and DWIs, which are crimes. But if it came out in testimony at a trial that an officer at the checkpoint said, well, we're just looking to see if there was any crime that was happening in this neighborhood or this area, that would make the checkpoint unconstitutional, unreasonable. The checkpoint can't be just looking for general crimes. It has to be for the specific purposes that are laid out. And part of that has to do with driving. I think at least some of what the analysis of the courts have been, because these the part of the reasons for the court saying that you can have a license checkpoint or DWI checkpoint is because they revolve around driving. But just general crime, looking for misdemeanor larcenies at a checkpoint wouldn't compute with a primary programmatic purpose there.
The only version of that I see somewhat deviates from that driving purpose that you're getting at is I know that one of the recognized legitimate forms of a roadblock or one of these checkpoints is to try to find illegal immigrants. So that's one of them. So that isn't necessarily a specific rote driving related offense.
No, it isn't.
But that is something I think the justification there was that there are a lot of times that different modes of transportation are used to transport individuals in that regard. So especially in different states along our border, that is much more of an issue than it would necessarily be here. And I would venture to guess that the justification for those checkpoints is much different than it would be in Texas than it would be necessarily here.
Yeah, I think that's right, because even with that, the court saying it's okay to do that, it would still have to fit some primary programmatic purpose. And I think attorneys would be able to challenge that. If it was a checkpoint for that purpose for illegal immigrants in North Carolina, then it would have to still comport with the Constitution there. But so that's probably why we don't see a lot of those here. But there's certainly those sorts of checkpoints in states like Arizona and California and stuff like that. So that's pretty interesting.
If you're just joining us here on WTOB, I'm Dylan Greenwood along with Harold Eustache, and we're here on For the Record with Greenwood Law, discussing checkpoints, an issue that does come up here in the state of North Carolina. And I would venture to guess it's probably going to come up a little bit more, especially as we get into the summer months and more people are going to be out and about driving. And it hasn't been as much of an issue this past year with not a lot of people out on the road due to the pandemic we've been going through. But again, I think it's something that's going to change. I know just here we've seen an uptick in DWI related arrests and seizures and that sort of thing, and I think that's just going to continue to go up, unfortunately. But a common scenario that we have seen in and around the Triad area is one over actually near Greensboro Coliseum That's a common place where checkpoints get set up. The road that comes out of Greensboro Coliseum as you go to Highway 40, long road, pretty straight, but as you get closer and closer to 40, you're pretty locked in on the road, and that's something that we talked about as being a common characteristic of checkpoints in general. And before you get on the highway, there have been frequent checkpoints that have been set up following events that happen at the Coliseum. Why? Well, because a lot of people go to the Coliseum. It's at night. Coliseum, most people may not realize this, can actually hold more people in it than Madison Square Garden in New York City.
Wow.
So there's a lot of people that can go there and be in an event. There's a lot of people that can go there and potentially drink and then afterwards potentially drive. Now, does that mean that everyone that goes through that checkpoint is coming from the Coliseum? No, but it could be used as a legitimation of the checkpoint that we know that people were at this event, we know that alcohol is served there, and we know that following that event they're going to need to drive home because people don't live at the Coliseum typically. They need to go home. And so there's just a few ways that they can get there. And so just using that as a jumping off point, we can kind of go through this constitutional analysis because it's a two-part test. First, like what we've talked about before, you got to look at that primary programmatic purpose. And you have to basically see is it for that legitimate purpose? Well, in a situation like that, it probably could be justified. If the purpose of the checkpoint is for DWI-related issues, and you know that there's going to be alcohol, and you know that people are going to be driving, that could probably be established pursuant to the Constitution. But then there has to be a balancing of three other factors, don't there, Harold?
There does, and that's part of the reasonableness. So there have been cases where the court said, well, there's a good primary programmatic purpose, but still the checkpoint is unreasonable. And so the court has to look at this balancing test of the gravity of the public concerns by the seizure, the degree to which the seizure advances the public interest, and the severity of the interference with individual liberty. So the court is looking at all these different factors. And so the first part is the gravity of the public concerns, and that looks at the importance or the purpose of the checkpoint. So again, that kind of goes back to primary programmatic purpose. Is this important enough for there to be a checkpoint? Is this important enough to the public for every vehicle to be stopped and the traffic to be stopped and have this whole big thing? And then the degree to which the seizure, which stopping a vehicle advances the public interest. And so whether this checkpoint is appropriately tailored to that public concern. So let's say, again, the concern is about DWIs, but if this checkpoint is not appropriately tailored that way and it's has some other factors that make it not appropriately tailored for DWIs, then it may not advance the public interest. And then the severity of the interference with individual liberty, which means this looks at how the officers conduct their discretion or discretion in conducting that checkpoint specifically. So, if officers are, have a DWI checkpoint, but they're walking up and saying, do you know about a robbery that happened at 3 p.m. To every vehicle and talking about this robbery or something like that, that doesn't comport with the DWI checkpoint.
Right,
and
then like on top of it, out of the 10 officers that are there, 2 of them are trained in administering DWI field sobriety tests.
Right.
And the other 8 have no idea what's going on or can do that or are trained to do that. And then you start going, well, this doesn't comply.
And that's an important point because courts have overturned checkpoints just on officers not having so the officers said that it was a DWI checkpoint, but there's no officers that have even done DWIs or don't have experience in standardized field sobriety
that's
testing.
an example of a deficit, but an example of a potential addition would be there's a canine on the scene.
Right.
Well, why is there a drug dog on the scene? What is actually the purpose of the checkpoint? If you're saying it's for licenses, if you're saying it's for DWIs, then why do you have a canine? If you're not trying to find other things.
Right. And so at these checkpoints, it does become this very the statute says that officers can find reasonable articulable suspicion after they interact with a person, with a driver, but it's got to be pretty fast in how they analyze that.
So we appreciate y'all joining us this Sunday here on WTOB. We appreciate you joining us each and every time you can here on For the Record with Greenwood Law. And don't forget to join us next Sunday at 10:30 a.m. here on WTOB as we present to you again For the Record with Greenwood Law. But Harold, before we go, send them off with that Greenwood Law Bill of Rights.
First is I will not represent myself in a court of law. I will not do law enforcement's job for them. I will not make statements when stopped by law enforcement. Of course, everybody has the right to remain silent. I will not consent to searches when asked by law enforcement. You have the right to not consent and have the right to have a warrant when there is a search. And I will not be my own star witness for the prosecution. We have these rules so everybody can stay safe and be informed. Please join us again. We thank you for joining us on For the Record with Greenwood Law.